Under the Federal Rules of Evidence, or FRE, the burden of production to rebut a presumption of fact in a civil action is generally on the party against whom the presumption is directed. However, this rule doesn't shift the burden of persuasion to convince the fact finder that certain facts are true, which generally remains on the plaintiff that brought the action. But what if a defendant effectively rebuts a presumed fact? Can the presumed fact still be considered as evidence? The Sixth Circuit considered this question in the case In Re Yoder Company. In 1981, the Yoder Company filed for Chapter 11 bankruptcy in the United States Bankruptcy Court for the Northern District of Ohio. In its petition for bankruptcy, Yoder sought relief from certain claims and creditors, including Mark Bratton, who'd filed a products liability action against Yoder in Michigan State Court. In response to the petition, the bankruptcy court issued an order setting July 13, 1981, as the deadline for creditors to file proofs of claim. Creditors, including Bratton, were then sent notice of the deadline by mail. On March 15, 1982, 8 months after the deadline, Bratton filed a proof of claim. In response, Yoder applied for an order expunging Bratton's claim. At a hearing, a Yoder employee testified that the company had mailed Bratton's attorney notice of the deadline to file a proof of claim. In response, Bratton's attorney testified that he didn't receive the notice. However, under common law, there was a presumption that an item properly mailed was received by the addressee. Following a hearing, the court issued an order of expungement, finding that Bratton presumably received notice of the deadline and his attorney's testimony that he didn't receive notice wasn't sufficient to rebut this presumption. Bratton appealed to a federal district court, which affirmed. In so affirming, the court found that a mere denial that a mailed notice was received wasn't sufficient to rebut the presumption of receipt by an addressee. Bratton further appealed to the Sixth Circuit.